Alex here with a legal nuts and bolts video on statutory construction. This is going to be one of the most technical videos I've covered, but I know I've talked about it a few times in some of my other videos, and I haven't explained what it is, and it's actually one of the most central legal doctrines that somebody could get their head around when it comes to the court system and how to sort of represent yourself. If you don't know how to read the statutes, and I don't mean read, okay, let me clarify. If you don't know how to interpret the statutes, then what's the point of knowing how to read them? And that sounds like a little bit contradictory, but it's not when it comes to the law, because first off, understanding the legalese, and I guess you could call it the legal mumbo jumbo, is only going to get you so far. Once you get your vocabulary expanded, and once you can sort of get used to seeing those types of words, when you read statutes, they tend to use a consistent type of language and verbiage, and like I said, vocabulary. You're going to get pretty far, but you're going to still get stuck because you're going to figure out that those statutes can be read many different ways. Not all of them, some of them. And you're going to also find that some of the statutes are contradictory. So you're going to have to figure out the rules as to how to deal with situations like that, because there are rules. It's not just something that the judge can just decide. The judge can't just say, I'm going to just pick the way that I want to read these, and that's what's going to control in this case. It's not how it works. The doctrine of statutory construction is something that I'm sure all 50 states have. There may be little different quirks and nuances and oddball situations in some states, or cases that cover like a nook or a cranny of a certain particular area that other states don't. But the general principles behind statutory construction are going to be consistent across all 50 states, because the United States tries to read laws in a way that's consistent. There has to be a consistent sort of set of rules as to how to do this, because otherwise it's going to be, just as I said earlier, it's going to be something where the judge can just decide what he, the judge can just decide it means what he wants it to mean, and then nobody can do anything about it. The statutory construction principles control on appeal. If your judge has not followed those principles, you can appeal, and questions of statutory construction are questions of law. And I've mentioned in my video, standard of review, that is a big deal. Questions of law are the ones that have the more favorable method of review. I'm not going to go into all the details now. In fact, if you want to see how that works and why it matters that questions of statutory construction are questions of law, watch the video standard of review, because it does matter. And 3 out of the 4 appeals that I filed, or 3 out of the 4 appeals that I won based on principles of statutory construction. So I really do mean it. If you figure this out, it's one of the biggest milestones. It's one of the things that's going to get you, I don't want to say on equal footing with the attorney and judge, at least not right away, but it'll get you a lot closer. And you'll be able to at least sort of, you'll be able to more confidently challenge your judge's interpretation of a statute. Whereas if you don't know what this is, you're just not going to have a clue. And whatever the judge says the law is, you're just going to end up trusting him. Same with the attorney. So anyway, with that, I'm just going to go straight into it. I'm going to do the best that I can because it's highly technical. The phrases that I'm going to use, I want to give a disclaimer. I know that they are probably not going to make any sense, but take those phrases and plug them into scholar.google and spend a few hours on it, and they'll start to make sense to you. If I try to explain it in this video, the video will turn into like an hour-long video, and I don't think anyone will get it by the end of it anyway. I don't know if I mentioned this, but there's really no example that I can give, because any example that I try to give is going to be just as technical as the contents of what the video is trying to cover anyway, so it's not going to help. So anyway, with that, I'll go into it, and best of luck. So the first step to statutory construction is determining whether or not the language of the statute is plain. If the language of a statute is plain, the plain language rule will apply. This is a thing, you can look this up. You can look up the plain language rule. The plain language rule is as simple as it gets. It basically binds the judge to the language of the statute. The judge cannot go beyond the meaning of the language. The judge can't even try to use logical policy considerations. What I mean by that is reading the statute in a way that seems to benefit the public policy of the state. The judge can't even do that. And the reason for that is because when the plain language rule applies, the judge and the courts have to assume that the legislature already considered all of the policy questions when they fashioned the statute. Not only did the legislature consider the policy arguments and questions, but they also debated them. And having considered them and debated them, they fashioned that language plainly in the way that they did on purpose because they wanted it to be applied the way it was written. That's kind of one of the areas that I think 2 of my 3 appeals basically involved the plain language rule. The judge basically went beyond the meaning of the statute. The statute stated I was entitled to costs. The language was plain. The judge tried to invent his or her own, I think this was actually both judges. One was a female, one was a male. Both of them decided that they didn't like how the language of the statute was written and they wanted to go beyond the meaning of it. And thinking that because they're the judge, they can do that, they went ahead and did that. It's not how it works because statutory construction is a legal doctrine and questions of law are not questions that the court will be given any deference on if you file an appeal. The way that the plain language rule works is not optional, it's mandatory. If a judge does not apply it correctly, the judge has made a legal mistake, and legal mistakes are more easily disturbed on appeal. 2 of the appeals I won on the plain language rule. It's even now as I sit here talking about it, it's really kind of surreal to think that I have to explain this thing like this because any ordinary person is going to think, duh. If a rule says a certain thing, you're supposed to follow the rule. And it's really unnerving to sort of sit here and tell everyone that I won two appeals on this because that means 2 judges didn't understand this basic legal principle, which is that they're supposed to interpret and apply the law existing as it is and not go and do what they want to do, not go and just kind of venture off. But it's exactly what they did. The plain language rule isn't that complicated. If a law says a certain thing, they're supposed to follow that law. Yet here I am. Anyway, I'm not going to get too stuck on that, but I just kind of had that realization as I was sort of going through this video. So if a statute has two or more different constructions, I guess I'll use that word. What I mean by construction is different sort of interpretations or meanings. I'm going to keep using that word. If you read a statute or a judge reads a statute and they can draw 2 or more different constructions from that, there are a few, and once this happens, you've gone beyond the plain language rule. You cannot apply the plain language rule to a statute that has 2 or more different potential constructions that come from it or arise from it because that statute isn't considered plain anymore. It's considered ambiguous. There are different rules that apply to interpreting ambiguous statutes. There's 2 or 3 different small, I guess I'll call them rules that apply to sort of helping eliminate possible constructions. And then after that, there's not really much more I can do for anyone else watching the video. You're going to have to just sort of venture out on your own and figure it out. But I'll go into those at least. The Supreme Court of Nevada tries to avoid accepting a construction that renders a statute or a portion of a statute superfluous or nugatory. Superfluous is pointless language, and it's pointless by virtue of it being somewhere else already. If statutory language is located in other areas of the law, then the construction you have right now, which kind of overlaps all that other stuff, is pointless. It's superfluous. The Supreme Court will try to avoid, I don't want to use Supreme Court, because judges are supposed to do it too, and attorneys. Basically, that construction will probably be set aside for another one if the other construction does not render parts of the law superfluous. Sorry that I can't use any examples, but you're going to have to look up these terms. The other problem, or the other rule, has to do with nugatory, with a construction that would render portions of the law nugatory. Unlike superfluous, nugatory is talking about nullifying or overriding or otherwise making a portion of the law have to be ignored. I guess that's the best way I can sort of explain it. That word is used too. If you look into scholar.google, you'll see that word referenced in cases that cover statutory construction. And so the same thing as with the superfluous. If you have, let's say you have two constructions and one of them, they both read like they're reasonable and they could apply, but one of them renders portions of the law nugatory, or like I mentioned, it nullifies portions of the law, then typically the other construction will be the accepted one because it doesn't do that. Say you have 4 different constructions. Say you have a really crazy looking law that could be read 4 different ways, and 2 of them render portions of the law superfluous, and 1 of them renders portions of the law nugatory. What's probably going to happen is they're going to fall back on that 4th one because it doesn't render any portions of the law nugatory or superfluous. It'll start to make sense when you start to read construction, when you start to read statutes and you start to see multiple ways that one could be read, and you start to see, hey, this way, if I read it this way, it actually eliminates the way that this law works. So that's probably not the one that they meant. They probably meant this way because this one doesn't render any parts of the law nugatory or doesn't nullify parts of the law. Same thing with superfluous. If I read these, I could read this law 2 different ways, but this one is almost pointless because there's these 2 or 3 different statutes over here that already say that. So it must be this other way that doesn't do that. I'm feeling like this might make more sense now. So I've covered that. The last thing that they try to do when it comes to ambiguous statutes is that they try to read them in a way that is harmonious with the other statutes, with the whole scheme. They don't try to read them in a way that you end up getting what they call, I think they call it unreasonable or absurd results. That doesn't sound right. No, that does sound right. They try to read the statutories, they tried to read the statutes within the statutory schemes harmoniously in an effort to avoid an unreasonable or absurd result. That's kind of like the phrase that I recall right now. I hope that this makes sense to people. I at least know that it's important to let people know that this exists and it's a thing and it's important. And there's just no quick way to explain it. It takes a tremendous amount of research. But once you figure out how the doctrine of statutory construction works, you will figure out how to not just read the law, but interpret it. Obviously, we're not attorneys. We're not here to try to act like attorneys because we have a choice. The whole premise behind the channel is we're forced to represent ourselves because we can't afford an attorney. And this is one of the most complicated things that they do and that they go to school for. And this is one of the biggest things that is talked about in the case law. And I hope that if the terms frustrate you and don't make any sense, I hope that you take those terms and put them into scholar.google or Westlaw and you search them because they will make sense after a while. And I guess with that, best of luck to everyone. As complicated as this is, it really kind of opens up a whole bunch of other doors for you. And so with that, I'm going to go ahead and end the video. If anyone has any questions, like if anyone has any specifics that they need help with, go ahead and post it in the comments below. I might try to help depending on my confidence with whatever particular question somebody throws out there. Hopefully it's not a really complicated statute that they need help with. With that, I'm going to go ahead and end this video, and I'm starting to see why it took me so long to do this video, because it was one of the hardest ones. Anyway, I'm going to go ahead and end this video, and I'll see you guys next time.